I've just opened the link for today.
Well, not to worry. Let's proceed. Where is Mr. Griffiths? Is he joining us, Mr. Pettingill?
My lord, I'm afraid I'm not sure, but I will be handling the matter and any response. So I think we're okay to proceed. I don't think he's going to be joining us at this point.
Okay, well, in that case, let's proceed.
My lord, yesterday.
I'm sorry, just not to interrupt my learned friend, but I just wondered. I'm obliged to my friend for the matters he sent through this morning, which I'm sure the court has, which I now have. I'm wondering if he was able to obtain the information that your lordship seemed to have an interest in yesterday, and I certainly did, about the recent outbreak and the information from the government about the people that were vaccinated in relation to those recent cases.
My lord, we are in the process of producing a further affidavit in which that information is going to be set out.
Thank you. I appreciate that.
Just to update, you recall we discussed yesterday the British government's position in relation to those who were fully vaccinated, whether they could travel without being quarantined. I see that at around 11:30 local time, the Minister of Transport advised the House of Commons that that was indeed the case. So going forward, it appears that certainly in the United Kingdom, those who are fully vaccinated, even if they are coming from, say, amber countries, they will be able to come in freely and without quarantine, unlike those who are not vaccinated.
Yes, my lord.
Sorry, I haven't seen that yet. And those that is the position that those are, and I'll look at it now, but that those who are not vaccinated are in mandatory quarantine at a hotel facility? Or?
I think that depends as to whether you're coming from red country or amber. But if you're coming from amber, then the present regime is that you have to quarantine at your home.
Yes. And so that's how I understood it. I will look at that it's only if it's a red country that it's more isolated. Thank you, my lord. It's an important point. Thank you.
It's on Sky News.
Thank you, my lord.
My lord, I think we finished off yesterday on page 9.
Yes.
And paragraph 19F of our submissions. And I'd like to take you to the authority of Rotherham Metropolitan Borough Council versus Secretary of State. That authority should be at tab 24 of the authorities bundle.
Yes.
By way of background, my lord, that case was heard before the Supreme Court. The Supreme Court found by a majority that decisions made by the Secretary of State for Business, Innovation and Skills concerning the allocation of European Union structural funding between regions of the UK was not unlawful. In particular, the court found the Secretary of State was not obliged to take into account transitional funding received by regions in the previous funding period. Essentially, my lord, it was a dispute between different regions of the United Kingdom with respect to funding. Those regions were Merseyside, South Yorkshire, which were being treated differently to Northern Ireland. But for
paragraph 1.
Yes, but for our purposes, the relevant paragraph is paragraph 61.
Yes.
Proper approach the court should adopt. My lord, you can see in our skeleton argument, we have referred to paragraphs 61 and 62. My lord, it may be helpful if you just have a brief read of those, because I will then immediately come on to the note that we sent this morning to give some context to the matter.
I read it in preparation. I have highlighted them, but let me read them again. Yes.
So, my lord, if I can now turn to the note that
I take it that the note has been given to Mr. Pettingill.
Yes, it has.
Yes.
It has, my lord, and I had the opportunity to read it briefly.
Yes, thank you. And thank you for producing that note. That's helpful.
My Lord, yes. My Lord, yesterday, I think in response to the questions that you posed regarding margin of appreciation, I gave a number of responses that I would like to put into context. First of all, my Lord, I think that we have to distinguish between margin of appreciation as it's understood in the European court context. And by European court, I mean margin of appreciation when that court is dealing with the degree of margin it will give to national governments passing national legislation. That's a different test to the margin of appreciation that has to be considered by a court like yourself when you are dealing with polycentric economic, social and economic decisions that a government will make.
The distinction between what the European Court was saying in the Czech Republic case,
yes,
and the decision by the minister to allocate resources.
Yeah, there is a difference between the two. It's a different test, and I just wanted to make sure I highlighted that. So, my Lord, although I think the Czech Republic case is of interest, I think it would be inapposite to rely upon that for the purposes of the decision you have to take with respect to the decisions that were made by the government in this case. So, my Lord, first of all, I want to get to what I call the nomenclature so that we can actually get the phrase correct that we are going to use. So paragraph 1 of the note, there are a number of phrases used to describe the same concept. Margin of appreciation, that's the Varica case. Diffidence, that's the Timberland case. Margin of discretion, that's the Rotherham case, which we've just read. And margin of judgment, which is the Dolan judgment that we read yesterday. Now, during our submissions, we have used those phrases interchangeably. And if we're going to refine the distinction and the test we're going to use, it's probably more appropriate that we use a phrase that is more generic to what we are doing, which is the margin of judgment. We say in paragraph 2 of the note that it is important for the court to determine in a particular case what the margin of judgment is. In essence, the question for the court is what level of scrutiny must be applied to how the respondents went about making the relevant decisions that they did. And my Lord, one of the authorities that my learned friends rely on, the Scottish minister's case, paragraph 106, helpfully sets out how that test should be applied. So, my Lord, at paragraph 106 of the Scottish minister's case, perhaps I can ask you to read that.
We read it yesterday, and in fact, I put part of it to Mr. Griffiths because that cites the case of Dolan.
Thank you, my Lord. Yes, thank you. And so then if we can go to paragraph 3.
Yes.
Leaving the Scottish minister's case firmly with the view that if there are certain issues that are polycentric, the government is given a wider margin. And if the court is not dealing with those kinds of issues, then the margin is not only narrow, but the level of scrutiny that the court imposes on those decisions is lower. Paragraph 3 is a reference to the weight that you place on the decisions that have been made by the government. Paragraph 3, this has also been referred to as the appropriate weight which is to be given to the judgment of the executive or the legislature, depending upon the context. Lord, we sent an additional authority. I don't know if you've had an opportunity to read it.
I did not, but I have it. I have the authority.
Well, I'll just briefly, the facts are briefly stated in paragraphs 1 and 2. In essence, it was a case where a transgender male wished to have himself recorded as the father of his child. And the issue was that the registrar refused to do that. And one of the questions that the court had to determine was what was the margin of appreciation that would be given to a decision of that kind. If you look at paragraph 80 of the judgment, I'll just read that out briefly. That point is relevant to what the Strasbourg court described as the margin of appreciation to be afforded to the contracting states in the application of the convention. The concept of a margin of appreciation is not directly relevant when courts in this country apply the Human Rights Act. This is because it is a concept of international law and not domestic law, governing the relationship between an international court and contracting states. Nevertheless, it is well established that there is an analogous concept which does apply in domestic law under the Human Rights Act. We can transpose the Constitution for the Human Rights Act, which has been variously described as a discretionary area of judgment, a margin of discretion, or in other ways, for example, to refer to the appropriate weight which is to be given to the judgment of the executive or legislature, depending on the context. And they refer to DPP and Keybline, and A versus Secretary of State for the Home Department, which is a reference to a judgment of Lord Bingham. So, I mean, that's the distinction between the two concepts in the two different fora, and it requires the court put certain weight on the judgments of the executive.
Yes.
So my lord, paragraph 4, section 13 of the order that we are dealing with in this case, and that's, I mean, subject, my lord, I say, to whether or not the applicants are challenging the statement made by the Minister of National Security, or whether they're actually challenging this order. But subject to that, all other things put aside, that order involved judgments about scientific data, allocation of resources, and policy choices of a social and economic nature. Now, we say that in all three contexts, the authorities suggest the margin of judgment should be wide. In all three contexts, the authority suggests the margin of judgment should not only be wide, but should be a wide margin of discretion. In Rotherham, that was with respect to allocation of resources, a wide margin of judgment. In Dolan, use of scientific data to inform legislation in the pandemic. And the phrase particularly diffident was used in Timberland with respect to policy, social and economic choices. So we say, my lord, that it is a question that you have to grapple with when you assess the evidence that we will go through based upon the Freitas test. And paragraph 5, the margin of judgment effectively permeates every factor in the Freitas test. And my lord, this is in response to the question that you posed yesterday when you asked how to apply it conceptually to the Freitas test. And my lord, can I ask you to turn to paragraphs 102 and 103 of the Scottish minister's case?
I have it.
Lord, it's a long section. Maybe I could ask you to read that, but it is going to be the approach that we take as we go through all of the evidence.
Yes, I mean, 102, again, I read it yesterday to Mr. Griffiths, but let me read it again. Yes, thank you. That was also the point I was making yesterday, that case has to be read quite carefully, because it was only ruled against the ministers because they had allowed people to congregate in other places, but otherwise the decision met most of the requirements of the Bank Millard test.
Yes, yes. So, my Lord, and also, have you had an opportunity to read paragraph 105 of the Scottish Minister's case?
Yes, I have it. I have it marked, and
Yes.
I have read it, and that's the point I was putting to Mr. Griffiths was yesterday. 105.2, a measure will be disproportionate if it's clear that the desired level of protection could be attained equally well by measures which were less restrictive. And I've read all the other subparagraphs.
Right. So, my Lord, we will be applying the approach used with respect to margin of judgment in the Scottish Minister's case in paragraphs 102 and 103 to the Limb 2 test in the Freitas.
Yes.
And the references we've made in paragraph 105 will be applying to the Limb 3, the Freitas test.
Yes.
But when we look at the margin of judgment in the round with respect to the De Freitas test, we say that the margin of judgment should direct the level of scrutiny or the weight that is to be given by the court to the challenged measure. And then we say that the approach or the lens through which the court considers the evidence probably has a two-stage approach. First, this is paragraph 7a. The margin of judgment should be considered when weighing the evidence. For example, if there is, in this case, contradictory evidence, for example, contradictory medical evidence, but we say that would have to be medical evidence that satisfies your test, my Lord, of being expert evidence, because we say we have filed expert evidence. The court should defer to the government on the margin of judgment if it is wide, because, and we say it is wide with respect to medical and scientific evidence. That's what the authorities say. And secondly, the margin of judgment should be considered when the court assesses what we have called polycentric judgments, allocation of resources, particularly the allocation of resources and any social decisions the court has made with respect to hotel quarantining. You will recall yesterday that there was a reference made by my learned friend to using the regiment and the fact that they had made some rough and ready financial calculations about which would be more economically cheaper for the government to do. Allow people to pay for their own stay at home, have ankle bracelets or other forms of checks, as opposed to hotel quarantining. Maybe the regiment could come out. Those are decisions that are economic, social decisions, which the authorities say you should give a wide margin of judgment to the government on. It's just not the place of the court to be substituting itself for the decisions the government make. And my Lord, the rationale and logic is quite clear, which I think you've said on a number of occasions. One, you're not in a place to make those decisions. Two, you don't know what other competing decisions the government have to make in order to make the decisions that they are making. And the court should not be substituting itself for the government. And so, my lord, we say that this is an important factor, which again, the applicants have provided no legal authorities on, made no written submissions on, and we say it's a critical decision, for example, that you can see in Dolan that you have to make, yet they've made no attempt to try and assist the court with any law or any analysis on how those polycentric margin of judgment decisions should be made.
Yes.
And so, my lord, I think when it comes to how you apply the margin of judgment, paragraph 8 sets out where that burden will lie. The margin of judgment applies in establishing both whether the measure is reasonably required, section 11(2)(a)(1) test, or it applies in the reasonably justifiable in a democratic society test, which is the test that the applicants have to satisfy when the burden shifts. So, my lord, that's going to be our approach on the margin of judgment.
There'd be no decision on constitution similar to ours where this issue has been considered.
The COVID issue.
No, the margin of judgment or appreciation is in the context of the constitutions which are similar to ours.
I can't say there hasn't been. I mean, we can certainly do a review and consider that, but I would have thought that there probably have been cases that may have come out of the Caribbean Court of Justice. If the court is concerned to find whether there have been other cases, we can look for that.
Yes.
During the course of the break. So, my lord, we now turn to the next section of our submissions, paragraph 20.
Yes.
As we said before, my lord, we have considered the issue of standing separate and apart from the issue referred to in section 11(1), which is whether the applicants have in fact been hindered in their rights. And we ask you to consider the two issues separately. I think you can tell, my lord, by the faint way in which we made our submissions in relation to standing, we're just leaving that for the court. But
yes.
I think that on the issue of hindered, there is a bit more substance to that argument. Lord, if I can again ask you to look at the case of Benavides, which is at tab 11 of the binder, paragraph 35. The case was in reference to a section 10 argument regarding freedom of association.
Yes.
But the context is the same because the wording is the same. But in paragraph 35, the court said the onus, paragraph 34 is probably more appropriate to start. To establish an infringement of section 10 of the Constitution, the plaintiffs must show that they have been hindered in the enjoyment of their freedom of peaceful association, the section 10 reference. Although no authority was cited to me on the point, I am satisfied that the hindrance must be more than merely trivial. And so just to contradict something that was said by my learned friend, Mr. Griffiths, yesterday, we're not suggesting in a pejorative sense that the argument that is being made is by the applicants with respect to their hindrance is trivial. We're just saying it doesn't satisfy the test. Then paragraph 35, the onus then shifts to the defendant to show that the hindrance is contained.
You have, I can't hear you, Mr. Duncan.
Can you hear me now?
Yes, I can.
Right. So essentially paragraph 34 is the important reference. And my lord, I think it's contextual. You have to look at the evidence that has been filed by the applicants. And you have to form a view whether or not their Section 11 rights have been or are likely to be hindered. My lord, we made these points before. No applicant has fixed plans to travel within the next 8 weeks on the evidence. Now, my lord, contextually, it'd be one thing if, as you put to me yesterday, this measure had indefinite life. But because it's going to expire on the 30th of September, that has to be seen against the background of the fact that nobody has produced evidence that they do intend to travel. And so for that reason, we say it is a live issue, and one that the applicants have to surmount as to whether or not they have established evidence that their rights will in fact be hindered.
Yes.
So with that, my lord, we can turn to paragraph 22 of the submissions and start the factual analysis under the de Freitas test for the argument of reasonably required.
Yes.
So paragraph 22, we assert that in de Freitas, the Privy Council did not clearly distinguish a test for reasonably required as opposed to reasonably justifiable in a democratic society. However, in the case of Benavides, Hellman said that the facts set out by Gubay, Chief Justice, would be both relevant and appropriate and applicable to both questions. And those are the factors that we are here to deal with this morning. First of all, whether the legislative objective must be sufficiently important to justify limiting a fundamental right. B, the measures designed to meet the legislative objective must be rationally connected to it. And C, the means must be no more than is necessary to accomplish the objective. So paragraph 22, and then we go to the heading A. Is the legislative objective sufficiently important to justify limiting a fundamental right? Paragraph 24, the Minister of Health states that the legislative objective in relation to public health and public safety is as follows. My Lord, if I can actually ask you to turn to the Minister's affidavit, paragraph 13.
I have it actually. It's
tab 15.
Yes.
So the order was considered explicitly having regard to public safety and health, as well as the government's resources.
Which paragraph are you looking at?
Paragraph 13. And the extent that any outbreak would cause disruption to the economy, education, and business. So, my Lord, based upon the note that we have produced, all those areas are areas where you should give the government a wide margin of judgment based upon the Rotherham allocation of resources test and the Timberland policy choices test. And the background as to why you should do that is set out in paragraph 14, which is the strain, the real concern the government had, the strain that was going to be placed upon the medical and health facilities, particularly the King Edward Memorial Hospital, in the event that there was no control of the spread of the virus.
Yes.
And, my Lord, if I could ask you to turn to tab 16, paragraph 25.
Just before you get there, in relation to that, there is the evidence filed by the applicants, particularly in the reply section. There is the sort of economic analysis by Mr. Evans. Did the reply affidavit by Mr. Evans, where he seems to suggest that
which affidavit, Lord? I think Mr. Evans has filed. He filed a first affidavit. I think there were two second affidavits.
Second affidavit, which was filed, I think, as a reply affidavit.
Is that the one sworn on the 5th of July?
I believe so. It is the one where he says that the risk to the hospital being overwhelmed is overplayed.
And which particular paragraph are you?
Do I have that? One of the affidavits suggests it, and maybe it was one of the other affidavits which suggests that the risk to the hospital is no longer a serious issue.
Well, first of all, I would say that I'd have to see the evidence as to how he came to that conclusion. And I think that because most of the evidence on what the risk to the hospital would be within the knowledge and provenance of the Ministry of Health, the court should defer to the Ministry of Health. And this is what we were saying. This is what we were saying when we sought to analyze, see, my Lord is still looking.
Yes, it's the section dealing with paragraph 21. He refers to Dr. Wesley Miller's evidence or his statement in relation to interview to Burn News, the number of beds, 28 ICU beds, 170 acute beds, 27 ventilators. And then paragraph 22, second paragraph, subparagraph. Whilst modeling this data, there was no obvious threat to KEMH resources. It is worth mentioning that this was also before Bermuda's vaccine rollout, and the majority of Bermuda's population was not vaccinated at the time. So I think the thrust of his evidence is that the position has now so improved that there's no serious risk.
Well, a few things.
I may just, it's also mentioned at paragraph 37 as he draws a conclusion on that with regard to KEMH and adequate resource capacity. Sorry.
No, that's fine. A number of things to say about that. First,
yes,
Lord, is that, as you had said previously, we were in a positive position before, and when the government relaxed the measures with respect to home quarantine, curfew, we got into a situation where, as the minister said, we had transmission attributed to a traveling passenger that potentially caused 21 deaths. That's point number one. Point number two is that this falls within the scope of the analysis I asked the court to conduct just now with respect to margin of appreciation. This is contradictory evidence to the evidence that you've received from the CMO, the minister, and the premier. The first question is, what weight can you put on the evidence that Mr. Evans has produced?
Yes.
It's a matter of pure logical provenance that the government is going to be in a better position to know what resources have been used and how they have been allocated. And it's also going to be in a better position to know the potential threat to those resources in the future. It's no negative comment on Mr. Evans that he takes information that he receives from various sources and seeks to draw conclusions. But it cannot be the same as the evidence that those within the position to administer those resources actually arrive at and determine a conclusion. It's just not going to be the same. And that is why the doctrine of the margin of judgment has been created, because the court can't intervene in those questions. The court's not here to delve into the resources of the Ministry of Health and determine whether or not they've been allocated in one way or another. And so, with respect, we're not suggesting that, the evidence of Mr. Evans cannot be referred to, but it has to be seen in the context that it's not going to reach the standard that is required on a, as they call it, polycentric question, such as allocation of financial resources for the administration of health services in Bermuda.
Yes.
I think we were about to turn to the Premier's affidavit, paragraph 25 of the skeleton argument. And this is in response to the first test under the Freitas requirement. And if I can ask you to turn to paragraph 5.
Yes.
Lord, perhaps I'll just read that out. The government of Bermuda has had to manage 3 outbreaks of the coronavirus in Bermuda. Following the latest outbreak that started in February, it was clear that more stringent border protection was required to stop the seeding of the new cases by travelers. The government formulated a policy that would allow the country to reopen its domestic economy with more stringent controls at the border based upon the risk that is posed by travelers. It was determined that until Bermuda achieved a higher vaccination rate, we would need to quarantine persons at the border who are at the greatest risk of contracting and transmitting COVID-19, namely unimmunized travelers. This shift in policy would reduce the risk of further outbreaks given the impact to the economy of repeated restrictions and increasingly virulent strains. So, my Lord, when it comes to an assessment of all the decisions, both financial and the social decisions with respect to the quarantining, we say, based upon a paragraph like that and the evidence like that, this court should be giving a wide margin of judgment to the policy decision that was made to create these regulations. And in paragraph 26, we turn to the chief medical officer. That's tab 19 of the colored tabs, paragraph 19.
Yes.
Or that follows into the site. That is a polycentric question where a wide margin should be given with respect to the scientific data. Paragraph 27. We say it's been noted in other jurisdictions that this approach has been taken. For example, in Dolan, Lewis J. considered whether COVID-19 regulations contravened Article 8 of the European Convention on Human Rights. He held as follows: the regulations seek to achieve a legitimate aim, namely the reduction of the incidence and spread of coronavirus. They do that by seeking to reduce the opportunity for transmission between households. That is a legitimate aim and is in accordance with the law, as the restrictions are included in regulations made under powers conferred by an act of Parliament. So we say section 11(2)(a) of the Constitution provides for legislative objectives that are sufficiently important. In the present case, the evidence is clear that the legislative objective is public health and safety. The government's policy is to control and prevent the spread of COVID-19 by quarantining unimmunized persons at the border who are at greater risk of contracting and transmitting COVID-19. And that's designed to protect just over 40% of the local population. We agree that figure is going down slightly, but they are either unvaccinated or not fully vaccinated, thereby allowing, as the Premier said in his reference in paragraph 5 of his affidavit, the country to reopen its reopen its economy. The second test in the de Freitas requirements is whether the measures designed to meet the statutory objective are rationally connected to it. That's just above paragraph 29 on page 12.
Yes.
Now, this is the section where we go into greater detail on the scientific evidence. This section breaks down the mandatory quarantine for unvaccinated travelers into its constituent elements, namely infection and transmission rates for vaccinated persons as compared with unvaccinated persons, the 14-day period, and the government authorized hotels and the cost to the traveler. Now, my Lord, a number of concessions were made by my learned friend yesterday with respect to the distinction between vaccinated and unvaccinated. It seems as if the real concern is the hotel stay and the cost.
Yes, I mean, to some extent, the controversy is relatively narrow in factual situations, as I understood from our exchanges with Mr. Pettingill. He accepts that there is a reasonable consensus in the scientific community that the risk profile of vaccinated and non-vaccinated people is different. He accepts that that would allow the executive to formulate policies which distinguish between the vaccinated and the non-vaccinated. He accepts that in principle there is no objection to a quarantine regime. He accepts that the quarantine regime can be policed either by the police itself or by the regiment. He also appeared to accept that the government could charge for the quarantine if the people were staying at home. The only issue which remains outstanding is that the government's decision for mandatory quarantine at government designated hotels is objectionable. And he says in relation to that, that the objective which the government is seeking to achieve, which he doesn't quarrel with, can be achieved by other measures.
Lord, yes. I think that it's probably best that I go through.
Yes, I think you should, but the controversy has been narrowed significantly.
Yes. So under the second limb of the de Freitas test, we deal with, as I said, 4 discrete issues. First, infection transmission rates for vaccinated persons compared with unvaccinated persons. Now, the issues raised here are: 1, to what extent vaccinated persons can be infected with COVID-19 and variants of concern as compared with unvaccinated persons. 2, to what extent vaccinated persons, if infected, can transmit the virus to others as compared with unvaccinated persons. And the further issues that arise are herd immunity and what is the approach that is taken in other jurisdictions that distinguish between vaccinated and unvaccinated persons. Now, it should also be noted that the applicants have provided no data or scientific evidence as to the rate of infection or the rate of transmission in vaccinated persons compared with unvaccinated persons. Certainly no evidence that would reach the level of expertise or from the level of expertise that you have mandated in your judgment in the interlocutory hearing. And we note that in the interlocutory hearing, you found that their evidence up to that point was silent on these issues. So dealing with the first one, rate of infection for vaccinated persons compared with unvaccinated persons. Now, paragraph 6A of the quarantine order defines a full course of vaccination as a COVID-19 vaccine administered according to the manufacturer's recommendation or the recommendation of a stringent regulatory body with at least 14 days having passed after the last dose. As such, the focus is on the data and scientific evidence of those who have received 2 doses of the vaccine and have tested after 14 days of the last dose. The data and scientific evidence that the rate of infection is significantly reduced in those vaccinated compared to those unvaccinated, we say is overwhelming. First, Dr. Karika Weldon identified 20 studies that have emerged from the United States, Israel, Scotland, Denmark, Sweden, and the United Kingdom, showing significant reduction in the rate of infection of those vaccinated compared to those unvaccinated. Of those 20 studies, there are 9 studies that demonstrate a reduction in rate of infection in vaccinated persons more than 14 days after the final dose of between 77% and 99%. Lord, if I could ask you to turn to the affidavit of Dr. Weldon, paragraph 17, tab 17, and paragraph 17 it is.
Yes.
So, Lord, you'll see that at paragraph 17, there is a reference to infection rates, and you'll see that the listing of the key findings of the studies is in relation to 14 days after the final dose. Paragraphs 18 and 19 refer to 7 days, but let's stick with 14 days after the final dose. My Lord, if I can then ask you to turn to tab 6 of the exhibits to her affidavit?
Yes.
Now, tab 6 is a study that was produced with respect to the prevention of COVID-19 by mRNA vaccines within the general population of California. And if I can ask you to turn to the results page, I mean, there are so many studies. My learned friend has had them, so he can take issue with whichever ones he seeks to take issue with, but I'm going to take you to some highlights in the study. And if I can ask you to read the last paragraph on the page of results, first page of results, among fully vaccinated cases, 45%.
Yes.
Lord, it is dense reading, but perhaps if you could just read the paragraph over the page. 3.4% of 5-2 cases were hospitalized. If you can just read that paragraph.
Yes.
If I can ask you to turn to tab 7. This is a study with respect to the effectiveness of the mRNA COVID-19 vaccines against SARS-CoV-2 infection in a cohort of healthcare personnel. So this was a study with respect to healthcare personnel. If I can ask you to turn to page 7. Discussion. I can read the first 2 paragraphs.
Yes.
And then, if I can ask you to turn to tab 8. This is a study in the Morbidity and Mortality Weekly Report. It's with respect to the effectiveness of the COVID vaccines preventing the SARS-CoV-2 infection among healthcare personnel. And if I can ask you to turn to page 497, bottom right-hand corner, there is a discussion. I'm not sure you need to read the first column, but if you read the second column,
Yes.
Over the page, my lord, the results are illuminating over the page, all the way down to halfway down the paragraph, commencing the findings. That's where you can stop. So there's a comparison of full immunization and partial immunization, and it gives the rates of protection with immunization.
Yes.
Lord,
there's never been much dispute that the vaccines, those who have been fully vaccinated, do provide a very substantial protection to the person who's been vaccinated. In terms of either being in terms of being infected, and if infected, whether they will be hospitalized or not. I mean, the evidence on that is quite clear. I think the only issue which was up in the air was as to the rate at which fully vaccinated people could be infected, and much more importantly, if they were infected, whether they could pass on to transmit to other people. And the studies coming back seem to indicate strongly that in relation to those issues, the rate of contraction of virus by the fully vaccinated is substantially lower. But much more importantly, there is a significant less risk of transmission, and on the basis that the viral load which a fully vaccinated person gets is insufficient for transmission purposes.
Well, Lord, yes. And, my Lord, I suppose I have to be careful and discreet in my submissions within the time we've got. But
Yes.
because of the nature of some of the comments in the public domain with respect to this topic at large, we decided to produce affidavit evidence with this kind of evidence behind it.
No, I think it's important to do that. It's important to do that.
Yeah, so that the court can at least have at its resource the information to publicly state in the ruling whatever it feels appropriate to explain to the public exactly what the position is the government has taken and why it's taken it. Whichever way the decision goes,
Yes,
can at least have that information within its armory to do that. So, my Lord, and I'm going to get through this reasonably quickly. I know.
No, I wasn't trying to hurry you along. I was just sort of giving you my understanding of the evidence to date. But please show me the passages you want me to see.
Yes, and so at tab 9, there is a report that has been produced with respect to the real-world effectiveness of a vector vaccine for COVID-19. And again, not to make this too long a read, if I can ask you to look at the results section, which is the second page of the report, but then turn over the page, there's a reference to how infection can occur after vaccination. If you can read the first paragraph at the top of the page.
Yes.
And then with the discussion section, this is a reference to the Johnson & Johnson vaccine. You can read the first 2 paragraphs of the discussion section.
Yes.
Now, at tab 10, there is an important study. This is an observational cohort study on the incidence of the COVID virus and the B.1.1.7 variant in healthcare workers, and importantly, by antibody and vaccination status. So, my Lord, if I can ask you to look at page 6. my lord, it is quite a long read, starting with the third paragraph, instance of any PCR confirmed symptomatic or asymptomatic COVID infection. And then if I can ask you to read that heading, the next heading, and importantly, impact of antibody status and vaccination on viral loads.
Yes.
So, my lord, the discussion is helpful because it synthesizes some of the information that you've just read. If I can ask you to read the first, second, and third paragraphs. I think that's helpful because it refers to use of both the AstraZeneca and the Pfizer vaccines.
Yes.
Well, and then finally, under this section, if I can ask you to look at tab 12. Now, tab 12 is quite important because this is a study from Israel, which has been a leader in the development and application of vaccines. And in fact, they've been a leader in the information they have culled together to produce reports on the effectiveness of the vaccines. If I can ask you to turn to the discussion page.
Yes.
Lord, if I can ask you to read the first paragraph under the discussion page.
Yes.
Lord, we are at paragraph 14, sorry, page 14, paragraph 33B of the submission. If I can ask you to turn to tab 19, that's the CMO's affidavit.
I have it.
Paragraph 25.
Yes.
Well, if I can take you to that study, which is at pages 33, that should be 35 in the footnote, not 25. We're just identifying the provenance of this document. You can see from his comments in paragraph 25, this is a research letter that was produced with respect to a study of employees at St. Jude's Children's Hospital. So, my Lord, can I ask you to turn to paragraph 33 of the exhibit?
I have it.
And if I can ask you to look at the results.
Yes, I have.
Yes, if you could just read the results.
Yes.
And the discussion on page 34.
Yes.
My Lord, in paragraphs 23 to 33 of the CMO's affidavit, he provides an analysis not only of additional studies he's relied on, but also a critique, importantly, of the evidence relied upon by the applicants. My Lord, it may be helpful to just take a moment and have a look at that, because it informs the information the CMO relied upon when he had to make a determination with the minister regarding the pandemic, and also informs how we should consider the evidence relied upon by the applicants.
Yes, thank you.
Lord, I'll just quickly read paragraph 41 of the CMO's affidavit, because he states, in the United States, the CDC has published information on its website about the efficacy of the COVID-19 vaccine against infection, symptomatic and severe disease, and hospitalization with COVID-19. It also published guidance on the relaxation of restrictions based on the efficacy. The CDC brief is exhibited at pages 117 to 135. Now, my Lord, I'm not going to have you go through all of that. I'm just going to give you some highlights.
Yes.
page 117 of the exhibit.
I have it.
Top left-hand corner, Center for Disease Control and Prevention, Science Brief COVID-19 Vaccines and Vaccination, summary of recent changes. This was updated as of the 27th of May this year. Lord, if you can have a look at the key points.
Yes.
Page 119. You'll see there's a heading at the middle of the page, Real World Vaccine Effectiveness. Multiple studies from the United States and other countries demonstrate that a 2-dose COVID-19 vaccination series is highly effective against SARS-CoV-2 infection, including both symptomatic and asymptomatic infections. And it says early evidence for the Johnson & Johnson vaccine also demonstrates effectiveness against COVID-19. You then see a table. Lord, I'm not going to take you through it all, but you can just quickly glance across and see what population is being the subject of the study, whether it's general adult population or healthcare workers. You can see the vaccine that they've taken. In some instances, it's Pfizer, some Moderna. And you can see the outcome and the effectiveness rate in the corner. From what I can see, nothing is less than in the 80 percentile, and that's mid-80s, and that was with respect to the United Kingdom.
Yes.
And then over the page, table 1B, effectiveness of COVID-19 vaccination against asymptomatic infection. And again, you can see the table is formulated where the sample is identified, the vaccine taken is identified, the outcome, and the percentage effectiveness of the vaccine. And again, the lowest level is 80%. Now, my Lord, critically, can I ask you to read the paragraph, the top of page 122, because it starts to get into a discussion of viral load.
Yes.
And then over the page, a recent study from Qatar demonstrated, if you could read, unfortunately, my Lord, it's the whole of that page, and I don't mind how much time you take, my Lord, but it is important.
Yes, thank you.
So, my Lord, next, it's paragraph D on page 14 of the submissions. The CDC science brief that we have just gone through also sets out studies on the rate of vaccine effectiveness against the SARS-CoV-2 infections, symptomatic disease and asymptomatic infection. That's what we've just gone through. The studies consistently show a significantly reduced rate of infection in those who have been vaccinated. Now, lastly, under this heading, Dr. Joanna Peden's expert report considers the effectiveness of the vaccine on the Delta variant present in Bermuda in the last few weeks. And she states as follows: data published in the UK showed vaccine effectiveness with one dose against the Delta variant as 35% and 79% with a second dose. This illustrates the importance of maintaining strong border controls against new variants. There is concern that a variant of concern may in the future undermine the vaccine program, and new variants coming into the country need to be closely monitored and controlled. Now, Lord, I should say, my Lord, before I get to the reference of Dr. Joanna Peden, I should say I have just been reading extracts, my Lord, from Dr. Weldon's affidavit. Now, my Lord, I don't know how you want to do this, but if I can ask you to turn to tab 17 in the colored tabs of the evidence bundle. That's Dr. Weldon.
Yes.
Right. And if I can ask you to read paragraphs 1 through 3 of her affidavit. Now, my Lord, further to your admonition in the last paragraphs of your judgment on the interlocutory hearing, I don't know whether you are formally going to certify the medical experts as experts for this purpose or not, but I do want to note Dr. Weldon's qualifications for the evidence she has given and put it on the record. And I am going to do the same thing with Dr. Peden as well. And that's the reason why I turned to Dr. Weldon first. I hadn't actually gone through her qualifications. All I'll say is this, my Lord, pursuant to the admonition that you gave in your judgment in the interlocutory hearing, we submit that Dr. Weldon is both eminently qualified and eminently qualified to give the evidence that she is giving in this case.
No, I accept that, and I accept that also in relation to Dr. Peden, Professor Peden.
Yes. So, my Lord, turning to Dr. Peden, who is at tab 18, and that's where we are in the skeleton argument. We are at paragraph 33E, and we are at paragraph 16 of her affidavit.
Yes.
And there she comments on the Delta variant and the effectiveness of the vaccine against the Delta variant. So in summary, under the first sublim of the argument in relation to the first aspect of the de Freitas test, we say in paragraph 34, as COVID-19 is a relatively new infection, the scientific literature is still emerging. However, the data and scientific evidence on the reduction of the rate of infection in vaccinated persons compared to unvaccinated persons, we say, could not be more emphatic.
Yes.
So we now turn to the rate of transmission for infected vaccinated persons as compared with infected unvaccinated persons. Now, the data and scientific evidence clearly demonstrates that the rate of transmission is lowered in fully vaccinated persons than in unvaccinated persons. Firstly, Dr. Weldon considers the reduced viral load in reducing transmission as follows. So if we can turn to tab 17 of the hearing bundle. Paragraph 20.
Yes.
Rate of transmission. Studies have shown that COVID-19 vaccination lowers the viral load detected, of which a high viral load is a driving factor for transmission of the virus. This falls in line with local Bermuda data. Now, my lord, there is a table that has contextualized the viral load assessment for Bermuda with respect to the March to May outbreak. Those unvaccinated only having one dose had majority low viral load values, whilst those with a second dose or fully immunized had majority high, what Dr. Weldon describes in her chart as CP values. My lord, perhaps I can give you a few moments to just look at that.
Yes.
Now, my lord, can I ask you to turn to the report Dr. Weldon exhibits at tab 3 of her exhibit. Now, my lord, this is a report produced in Nature Medicine.
Yep.
It's the initial report of the decreased SARS viral load after inoculation with the BNT 2B2 vaccine. Now, Lord, I have read this report and have marked up a substantial portion of the first page. It is quite relevant. Can I give you as long as you need to just have a look at that?
I had read the first paragraph, but let me read it again.
Well, my lord, it's actually most of the page is relevant on viral load.
Yes. Yes.
Well, if I
Right
can ask, yes, if I can ask you to turn to tab 4
Yes.
to study again on transmission of the virus. The study was done in Spain. Again, it's a study with respect to viral load. You'll see in the summary and background. And I can just ask you to look at discussion, just the first paragraph. First paragraph and the next 2 lines talk about how large the study was.
Under discussion, what page is that?
Sorry, that's 634, bottom left corner of the page, 634.
Yes. Yes.
Lord, and paragraph 35B, the chief medical officer also explains why the rate of transmission is reduced in fully vaccinated persons by reference to the study as follows. He says, one study from Israel, one of the early leaders in COVID-19 vaccinations, gives some clues about what's behind the reduced transmission. Researchers identified nearly 5,000 cases of breakthrough infection in previously vaccinated people and determined how much virus was present in their nose swabs compared to unvaccinated people. The amount of virus detected was significantly lower in those who got vaccinated. The risk of transmission is related to the viral load. The authors suggest that this implies reduced risk of transmission in vaccinated individuals. And if I can ask you to turn to tab 19, the CMO's affidavit. You can see, my lord, he relies on the
Paragraph.
same, sorry, my lord, it's paragraph 26 of the CMO's affidavit, and he in turn relies upon an exhibit that we've already looked at, just showing you that he's relying on the same report from Nature Medicine.
Yes.
Now, if you can stay with the exhibit to the CMO's affidavit, he also cites a report that we have already looked at as the basis for his conclusion. So we're on paragraph 35C of the skeleton argument. The CDC science brief states as follows: data from multiple studies in different countries suggest that people vaccinated with the Pfizer COVID vaccine who developed COVID-19 have a lower viral load than unvaccinated people. This observation may indicate reduced transmissibility as viral load has been identified as a key driver in transmission. 2 studies from the United States found significantly reduced likelihood of transmission to household contacts from people infected with COVID, the SARS-CoV-2, who were previously vaccinated. And my lord, I don't have to take you to it, but he refers you to page 122 of his exhibit, which we've read already. And that is the quote that you have looked at already at the top of the page. Lord, paragraph 36, the chief medical officer sets out in detail the range of scientific and medical information and data he receives as he leads Bermuda's public health response to the pandemic. The CMO then states as follows: I have not been made aware of any significant study of the vaccine that indicates there is no reduction in the rate of infection and transmission in vaccinated individuals. However, even if such a study or science evidence did exist, it would be difficult for that to outweigh the significant body of medical and scientific evidence of which the above, and that's the exhibits we've been referring to, is merely a portion. Lord, and the evidence from which that submission came is found at tab 19 at paragraphs 6 to 13. And you've already had a look at those paragraphs.
Yes.
So, my Lord, the third limb is herd immunity.
I was
Paragraph.
wondering, Mr. Duncan, whether we should take the morning break before you get into that section.
Yes, I'm quite happy to take a break.
So let's,
yes, before we go into herd immunity, yes.
Let's take a break for 10 minutes and we will resume then. Well, 11, we'll come back.
Lord, yes.
Good.
Thank you. They're all-
Yes, Mr. Duncan.
Well, yes, we had reached the stage of herd immunity,
Yes.
paragraph 37 of the skeleton argument. When considering whether the mandatory quarantine is rationally connected to the statutory objective, it is important to consider herd immunity. Herd immunity forms part of the statutory objective as it will provide protection for those that cannot be immunized. Dr. Weldon explains what herd immunity is and its application to Bermuda as follows. If I can ask you to turn to affidavit, which is at tab 17, paragraphs 28 to 30.
Yes.
Lord, if I can ask you to read that.
Yes, I had read it before.
Okay,
Thank you.
Lord. Yeah, and for the purposes of the record, I will just briefly say that she confirms in paragraph 28, herd immunity is the amount of people in a population that are needed to be fully vaccinated in order to provide overall protection from certain disease. During herd immunity is less likely that someone can spread the disease to another and extends beyond those who are immune, but also cover those who are not immune. And in 30, as a result, and given the presence of variants on the island or the potential for variants to spread, Bermuda has not had a sufficient percentage of the population vaccinated to establish herd immunity. Lord, if I can ask you to turn to tab 23 of her affidavit.
Yes.
There is a report that has been produced. What is herd immunity? And it's been produced by the Mayo Clinic, and you can see herd immunity occurs where a significant portion of the population becomes immune to an infectious disease, limiting further disease spread. And my Lord, can I ask you to read, how is herd immunity achieved?
Yes.
And then herd immunity and the COVID-19 virus.
Yes.
So turning the page, my Lord, of the skeleton argument, paragraph 38, Dr. Newton, a specialist in infectious disease management and runs the Public Health England, UK and overseas territories team that supports the UK overseas territories control and spread of the coronavirus and variants of concerns, has advised in relation to the impact on vaccination uptake on border reopening. In relation to fully vaccinated individuals, Dr. Newton considers to be quite straightforward. However, reopening borders for unvaccinated individuals was considered dependent on local uptake. So effectively what that means is the unvaccinated travelers would get the benefit of herd immunity from the vaccinated travelers. Can I ask you to look at paragraphs 34 to 36 of the Chief Medical Officer's affidavit at tab 19. Lord, and I will just briefly go through that. Dr. Newton's reference is contained in paragraph 35, but I will actually start paragraph 34.
Yes.
Above, I referred to medical experts that provide advice to the department. One such expert is Dr. Newton, who is a specialist in infectious disease management. Dr. Newton runs the Public Health England UK Overseas Territories team and provides information and advice along with her team to support overseas territories and control the spread of COVID-19. On the 7th of June, Dr. Newton emailed me, amongst others, in other UK overseas territories, specifically in relation to the impact on vaccination uptake on border reopening in relation to fully vaccinated individuals. Dr. Newton considers this to be quite straightforward. However, and this is the important point, reopening borders for unvaccinated individuals was considered dependent on local uptake. I understand that Dr. Newton was asked to provide an expert report in relation to the above, but given the intensity and volume of her workload in dealing with the pandemic, she was unable to meet the expedited timetable to produce such a report. And if I can ask you to turn to page 49 of the exhibit.
I have read the email.
Lord, if you've read that email, then that's fine. Won't detain you longer with that. Lord, paragraph 39, if I can ask you to read paragraph 39 of the skeleton argument, that's where the chief medical officer sets out the figures for those vaccinated in Bermuda.
That figure still stands if the dominant variant is Delta.
That's correct.
Dr. Wilton seemed to suggest that it would be higher in our affidavit.
Yeah, I think that it may be subject to review now, but certainly at the time of production of the affidavits, those were the figures.
Yes. Yes, thank you.
Roman numeral 4 under this heading, dealing with the first limb of the de Freitas criteria, other jurisdictions distinguishing between vaccinated persons and unvaccinated persons. Lord, of course, Bermuda has to march of its own drum, but in the interconnected world that we live in, with air travel, we have got to consider the policies that are being taken by other larger countries that come here and other countries of a similar size and population demographic. So in paragraph 41, we say that there are other jurisdictions that distinguish between vaccinated and unvaccinated individuals for the purposes of mandatory quarantine for travelers. I've just read the email from Dr. Newton that, my lord, you said you've had reference to. You saw her reference to policy considerations. In paragraph B, Bahrain, Barbados, Canada, Cayman Islands, Poland, and Saudi Arabia all distinguish between vaccinated and unvaccinated for the purpose of mandatory quarantine. And you're saying, my lord, this morning you're hearing the UK is joining that list.
Well, as far as the UK is concerned, that was only in relation to vaccinated people. They had, as you know, they've had a regime based upon green, amber,
yes,
and red lists. In relation to amber, the position used to be that you had to quarantine a period of 8 days. But now it is apparently going to be changed so that if you're vaccinated, even if you come from an amber country, you would be allowed without any quarantine. So if you're fully vaccinated, you can come in. Not sure whether that applies to the red lists. I don't know the answer to that.
Right.
In relation to these countries under B, I mean, they have mandatory quarantine. Do you have an understanding of what kind of mandatory quarantine they have? Is it like the one which is proposed here, namely government mandated quarantine in a hotel designated by the government?
Well, I think we know that that's the case in Canada because of the evidence that we had and the submissions that we had before the hearing. And Lord, I think that Lord, if we can just turn to the Premier's affidavit, just so that you can see where I'm reading from, Lord.
Yes.
If you look at paragraph 51 of the submissions, there's a footnote 54, and that takes us to the Premier's affidavit, which is tab 15, exhibit pages 21 to 26.
Yes, I think I have tab 16. I have it.
51. Right. And my Lord, also, let me just have a look at that. Make sure that's the right reference. Sure that's the right reference. You can see that in paragraph 51 of the skeleton argument, we refer to similar regimes. I just want to check whether the exhibit reference is helpful. Just want to check whether that's helpful. And Lord, we see page 21, there's reference to the UK, quarantine hotels. Which
that is in relation to the red list, I believe.
Yeah.
The government mandated.
Good. Well, I'm just looking at the page 26 of the same exhibit.
Yes.
There's a reference to Ireland and Norway. Right.
I mean, if you look at New Zealand, for example, which is at page 23, I mean, that is anyone entering into the country must enter into a 14-day quarantine in a government-managed hotel or facility with daily checks carried out by health professionals.
Yes. And my Lord, paragraph 12 of the Premier's affidavit also sets out the jurisdictions, he says, that have a similar regime.
Yeah, he says that mandatory hotel quarantine also required the individuals to pay. For example, Australia, Canada, the United Kingdom, Singapore, Trinidad, and Tobago.
And then there's a reference to the cost in the last sentence.
Yes.
So, Lord, I'm on paragraph C on page 18.
Yes.
And I'm taking you to footnote reference 39, which is page 50 of the Chief Medical Officer's affidavit, which is at tab 19.
Yes.
The extract is there, but you can see the actual evidence, page 50, and that's a reference to Canada, which we already had some indication of from the interlocutory injunction hearing.
This the Canadian situation, does that apply to Canadians entering Canada back? I think the case suggested that was the case we looked at.
Yeah, we looked at two cases. I can take you back. They're actually in the bundle if we want to get the exact references. Although it's a moving target, certainly as far as their position in June, that clearly was the case. You'll recall, my lord, that one of the arguments that they had there was the distinction between travelers returning to the country by car as opposed to travelers returning by air. They had a different regime for air travelers. And that regime was a very restrictive quarantine. And they had two grades of facilities depending on where you came from and degree of risk that they felt that you posed to the country. So, Lord,
it is dealing with Canadians as well, because some of the statements clearly are made in the context of Canadians returning home, like at page 53 from Mr. Bill Blair, Minister of Public Safety and Emergency Preparedness. Yes.
So, my lord, is that page 50 of the CMO's exhibit that you were looking at?
Yes, the page 50 continues that document, and I was referring to the statement at page 53 from Mr. Blair.
Oh, I see. He is the Minister for Health?
The Public Safety and Emergency Preparedness.
Right. Yes. Yes. Lord, I think that was footnote 39 I was at, and moving on to paragraph D, 41. I just want to check that, yes, although you may have seen this reference before, we may not have focused particularly on this paragraph. Lord, I'm at paragraph D on page 18. It's the same CDC report that we've referred to before.
Yes.
But there is a reference in the context of quarantine to pages 131 to 135. Actually, I don't think we have seen this before. This is a CDC report. It's entitled on page 131, Summary of Recent Changes, Updated Choosing Safe Activities infographic with new considerations for the examples activity for outdoor gatherings with fully vaccinated and unvaccinated people. The relevant paragraphs are on pages 134, international travel, And you can see, my lord, domestic travel within the United States or to a US territory and international travel. They have certain quarantine restrictions. If you're fully vaccinated, effectively, you don't have to quarantine. So, my lord, trying to move along. Paragraph 42 of the submissions. The Minister of Health has stated that she has had to make difficult judgments about the medical and scientific issues. There is clearly a considerable body of data and scientific evidence that demonstrates that the rates of infection and transmission are significantly reduced in vaccinated persons compared to unvaccinated persons. In the circumstances, the Minister of Health's decision to treat vaccinated persons differently to unvaccinated persons is consistent with that data and scientific evidence. It's based on the clear advice of experts and is in accordance with the practice in several other jurisdictions, a practice that seems to be increasing as more people become vaccinated. And my lord, the only footnote I would want you to put at that point is that based upon the evidence that you've heard, this would be a Dolan type, both Supreme Court and Court of Appeal. Sorry, High Court. I don't think it went to Supreme Court. It was the High Court, Mr. Justice Lewis.
Yes.
And Court of Appeal margin of judgment issue that you would have to grapple with, and it is our firm submission that whether taken separately or in consideration of any opposing evidence that you qualify as expert evidence, you should give a wide margin of judgment to the minister with respect to the scientific and medical information that she relied upon to make her decision with respect to these regulations. So we next turn to the 14-day quarantine period.
This is as to whether it should be 14 or some lesser figure. Yes.
And there is scientific evidence in support of that.
Yes.
So, my lord, if you just look at paragraph 43 of our skeleton argument, that's where we think we stand in contradistinction to the applicants at this stage of the proceedings.
I think there is some affidavit where it's suggested that perhaps 14 days is too long because it's only a minimal number of people who are found to be infected on day 14. I can't remember which affidavit it is, and it's in one of the reply affidavits.
Right. Well, I think in that respect, we do have a live issue that's joined then, and we're going to go through the scientific evidence. But
yes,
once we conclude that, we'll be asking you to weigh the evidence from the respective experts and give it the requisite weight that it deserves based on their expertise.
It's in the same position as what you submit under paragraph 42.
Yes, that's correct. So, paragraph 44, the data and scientific evidence to support a 14-day quarantine is as follows. There is a report published that is referred to paragraph 10 of the affidavit of Dr. Weldon.
Yes.
So, and I'll just, for the record, read that out. The quarantine period was decided based on the known incubation period for the virus from initial studies at the onset of the pandemic. The median incubation time was determined as approximately 5 days. However, the range of incubation observed was between 2 to 15 days. 95% of cases experienced an incubation period of 13 days or less, and so a 14-day quarantine period became standard. And Lord, I may as well read paragraph 11 of Dr. Weldon because it's referred to in the next footnote.
Yes.
The current CDC guidance is to complete a 14-day quarantine. As stated by the CDC, the recommendation for a 14-day quarantine was based on estimates of the upper bounds of the COVID-19 incubation period. Quarantine's importance grew after it was evident that persons are able to transmit the virus before symptoms develop, and that a substantial portion of infected persons, likely somewhere between 20 to 40%, never develop symptomatic illness, but can still transmit the virus. In this context, quarantine is a critical measure to control transmission. Although alternatives are given by the CDC for shorter periods, i.e. 7 to 10 days, they state clearly that any option to shorten quarantine risks being less effective than the currently recommended 14-day quarantine period. So, Lord, there is a report, tab 1, of Dr. Weldon's affidavit. This is a report produced by the Infectious Diseases Society of America, and it is in the Journal of Infectious Diseases. It's described as a major article.
Yes.
Epidemiological characteristics and incubation period of confirmed cases with the virus outside the Hubei province in China. And the importance of this study is referred to in the results. Lord, and if I can ask you to look at the discussion, which is on page 31 in the bottom right-hand corner of the page. And just read the first column under discussion through to the first paragraph on the second page.
Yes, thank you.
And my Lord, next, page 20, paragraph C, which is a reference to paragraphs 12 to 14 of Dr. Weldon's affidavit. Lord, if I can ask you to read those paragraphs.
Yes. I mean, that shows that even on day 14, 9% of the people were found to have contracted. I mean, day 14, in total 26 out of the total 135.
That's correct.
24.
Yeah. And you can see what Dr. Weldon says in paragraph 13 of the affidavit. Since the airport opened on the 1st of July 2020, the testing lab has tested all incoming travelers on arrival and most of their follow-up post-arrival testing. As of June the 21st, 2021, the testing lab has identified 260 travelers. Of this total, 125 cases tested negative on arrival, then converted to positive during the 14-day quarantine period. Those that tested positive on days 6, 7, and 8 had negative day 4 tests. Those that tested positive on days 9, 10, 12, and 14 also had negative tests on day 8. And then she sets out the breakdown in a chart.
Yes. The other point you get from that chart is that of the total number of infected people, 260, 249 were not immunized and 11 were immunized.
Well, yes. And we're hoping to get some evidence on that today. That's what we're hoping to produce.
So that's less than, so just looking at the figures, less than 4% of the total
We're immunized.
infected population.
Yeah.
Less than 4% of them are fully vaccinated. If the total figure is 260 and 11 were immunized, I'm doing math, something like that.
Yeah. Well, I think that I was at yes. I'm on paragraph 44D on page 20.
Yes.
And my Lord, there is a reference there to what Dr. Weldon says is the basis for the reasoning behind vaccinated persons not having to quarantine for 14 days. And what Dr. Weldon says is usually new pathogens have around 14 days to infect cells in the body and multiply before the immune system is able to mount a substantial defense. Vaccine immunity prepares the body's immune system to attack a pathogen of interest for when a natural infection may occur. In the case of this virus, this shortens the time needed for the body to fight off the virus. This usually results in a shorter infection period and lower viral load. Paragraph 45, the chief medical officer and the minister also explained the policy reasons behind the decision to impose a 14-day quarantine period. If I could ask you to turn first to paragraph 45 of the chief medical officer's affidavit at tab 19. Where the chief medical officer says, further, the ease with which the virus can spread in such a small jurisdiction and the limited resources are also reasons to exercise caution. It should be noted that the Cayman Islands, with a population similar to that of Bermuda, requires all unvaccinated visitors to quarantine in a hotel for 14 days. The Cayman Islands has a total of 609 cases and a total of 2 deaths.
Does that apply to residents, or it says visitors to quarantine, i.e. returning visitors, or just?
I can find out, but I don't know if, I can certainly make a note to find that out. And if I can ask you to turn to tab 15, that is the minister's affidavit, paragraph 14.
Yes.
I can ask you to. Yes, 50, sorry. And that is paragraph 14. Have a read of that.
We looked at that before, I think.
Just give me one moment, Lord. What page is that? I'm just being referred to page 84 of the exhibit to the CMO's affidavit in response to the question you just asked. Also, if I can ask you to turn to page 84.
Yes, I have that.
And then you can see it's a Cayman Islands press conference, and there's an explanation of the COVID protocols from the 23rd of June. You see non-vaccinated travelers must complete 14-day quarantine. Residents to pay for their own stay following non-essential travel.
So that suggests that it applies to everybody.
Residents pay, yes.
Residents to pay for their own stay following non-essential travel.
Non-essential travel, yes.
So that is materially identical position to us.
Yes. We don't know what the exemptions are in the Cayman legislation, but we have our exemptions here, which equate to essential travel in certain circumstances for certain categories of people. Lord, over to page 21, I'm moving on.
Yes.
Paragraph C, this is still under the requirement concerning hotel stay. The court should take into account the approach taken in other jurisdictions that are similar to Bermuda by way of illustration. The Cayman Islands have a population similar to that of Bermuda and require all unvaccinated visitors to quarantine in a hotel for 14 days. We've just looked at that reference. The Cayman Islands has had a total of, and we've also seen that from the CMO's affidavit. So we say there is a clearly considerable body of data and scientific evidence that demonstrates that a 14-day quarantine period is necessary to ensure public safety. The likelihood is that 21 deaths resulted from an individual who breached quarantine on day 12 and tested positive on day 14. There are policy reasons behind the decision to impose 14 days, such as the size of the jurisdiction and available resources to combat an outbreak. Further, a 14-day quarantine period accords with other jurisdictions in a similar position to Bermuda, for example, the Cayman Islands. As such, the court should not interfere in a Minister of Health's decision to impose a 14-day quarantine period. My Lord, and again, we say that having considered this limb of the De Freitas test, you would then look to the Timberland test, and I'm referring to the case in paragraph 4 of our note.
Yes.
With respect to the margin of judgment, not appreciation, that you should give to the minister when making these decisions. We're now on to government authorized hotel.
I think this is the only real contentious point, seems to me.
Yeah.
That,
that's what I understood from Mr. Pettingill's submissions yesterday.
yes, that the submission is made that we accept quarantine. We accept. We don't necessarily contend that there should be no quarantine, but it should be at home as opposed to government mandated. And
well, I just qualify that to say this, my Lord. I think my learned friend, and he will correct me if I'm wrong, I think he flirted with the issue of concessions on cost, which is the next submission I made on page 23 of the skeleton argument. But I got the impression that that was a moving target. And so I think I have to address that full on.
So is this whole subject that the residents should be allowed to quarantine at home, and there can be all sorts of measures imposed, police inspections, regiment inspections, big signs, and the like, as opposed to government mandated. I think that's really the strongest point. And
yeah,
I confirm that, my Lord. That is the crux of the applicant's argument.
So would it be right to say then, I'll go through it briefly because I think they're interlinked, that there is no objection on the issue of cost because these elements all interweave. And what I don't want is some kind of a reduced assertion in relation to the government hotel and an increased attack on the issue of cost.
Well, Mr. Pettingill was suggesting yesterday that the cost could be utilized for other purposes.
Yes.
i.e., the suggestion was that he wasn't objecting to the cost. I don't know what position is. Well, perhaps you can clarify, Mr. Pettingill.
I'm sorry, my Lord, I missed that last bit.
Perhaps you can clarify your position in relation to
yes,
cost.
my Lord. My submission with regard to that was one could see where if there was to be any cost that was applied, instead of applying it to, and I'm saying, by the way, oh yes, they want to pay costs. What I was saying, if we on a watered down version, if you will, instead of applying costs to a hotel stay, that any costs that were warranted could be applied to any increased observation, that may need to be take place because people were at home, either by the regiment, health workers, or so on and so forth. If necessary, that would be the appropriate use of any costs for quarantined individuals at home. Just like they have to pay a fee with regard to other things, one gets that's fees involved. And certainly if the position were, not having to stay in a forced mandatory quarantine in a hotel, but having to stay at home, and it was necessary to have increased checks or some form of increased provisions, that there may be some cost associated with that.
So I think you should work on the basis that the issue of cost is still in play.
Yeah. Because my concern, and the reason why we have to address it full on, is I'm not sure how the court is going to approach this. We don't divine or detect these arguments from the pleadings. These are arguments that are just being made. So I'm just putting a marker down that the court has to consider that. What approach the court takes is a matter for the court, because this is a matter of public interest, and the court may want to form a view to resolve the issue. But these are arguments we're responding to some extent off the hoof, because they're not in the pleadings. So, Lord, let's deal then with page 21, government authorized hotel.
Yes.
And this is where we get substantially into the evidence of Dr. Peden. So the data and scientific evidence demonstrates that hotel quarantine is more effective than home quarantine. Dr. Peden, specialist in infectious disease management, considered the scientific literature in detail and concludes that home-based isolation, which is reliant on personal compliance, will therefore inevitably lead to increased transmission. Now, Dr. Peden also considers reasons for a lower rate of adherence to home quarantine and the survey and qualitative data for adherence to home quarantine. First, my Lord, can I ask you to look, I'm not sure whether we've seen it already, but paragraph 45 of the Chief Medical Officer's affidavit at tab 19.
Yes, we have seen it.
Right. And then next, which I don't think we have seen, is paragraph 6 to 11 of Dr. Peden's affidavit.
Remind me, what tab is that?
Tab
18.
Tab
I
8.
have it.
Lord, I'm going to give you a moment to read that, because this is a significant issue and she is the expert that has given cogent evidence on this point.
I have read her affidavit a number of times, but I'm quite happy to just take another glance.
Lord, if you don't need to, that's fine, but that is the part we are.
No, I understand. It's an important evidence, and as I say, I have actually read it a number of times.
She essentially relies on a Dickens report that we're going to refer to.
Yes. Just before you get into the meat of it, what do you say to Mr. Pettingill's argument that, well, that is England, that doesn't apply to Bermuda. He says it doesn't apply to Bermuda because we are a small jurisdiction, and it's much easier to control home quarantine than would be the case in the United Kingdom.
The evidence doesn't support that. The evidence of the outbreaks in Bermuda is completely against that argument. I mean, it's one thing to talk about the evidence of measures that can be placed upon the person arriving home to Bermuda. It's another thing to deal with the issue of visitors, which has been one of the problems, the visitors to the home, and the problem that's caused when either they are infected or they become infected by the person who arrived in Bermuda and is at home.
So this is visitors staying in hotels?
No. Visitors to the home of the person who has
Oh, I
arrived.
see, yes.
That has been part of the problem. And so, and that's been an international problem that has been faced. It's not just a local problem.
And that's because nobody wants to actually report that.
No, nobody wants to report that. I mean, somebody comes to your house, you're not going to report them to the authorities. It's viewed as an innocent visit. You know, sometimes it can be a fleeting visit, but those are the visits that sometimes can cause transmission of the virus.
Yes.
And so that's not just a local issue, that's an international issue. And there's reference to universal themes on the ability to constrain transmission from those who are quarantining at home in the reports and how limited it is. And we'll come to that. Cool.
Yes.
Well, yes, my lord. I was just looking at the minister's affidavit to see if there's anything relevant there. But, my lord, yes, you've said that you've already seen paragraphs 6 to 11 of Dr. Peden's affidavit.
Yes.
Lord, I can now ask you to turn to Exhibit 1 to affidavit. This is a report exhibited to the affidavit of Dr. Peden. It's entitled Institutional, Not Home-Based Isolation Could Contain COVID-19 Outbreak. Lord, I mean, I have many parts of this highlighted. I could take you through them as a hop, skip, and a jump. I mean, the first column, there's a paragraph beginning compliance.
Yes.
If you could start there and read to the next column to the paragraph ending identified and isolated.
Yes.
If you could then start at the foot of the second column, the model represents a large city of 4 million residents, and read over to the end of, actually, my lord, it's, if you could read from there right to the end of that page.
Yes.
And over the page says compliance will therefore inevitably lead to increased transmission. And I think that's all we need to read on that one, my lord. And then if I can ask you to tab 2 actually is just in the event you need it, it's Dr. Peden's qualifications.
Yes.
And then tab 3, adherence to test, trace, and isolation system in the UK. results from 37 nationally representative surveys. The objective of the combined study was to investigate rates of adherence to the UK's test, trace, and isolate system over the initial 11 months of the pandemic. Or if I can ask you to read conclusions, it's on that same page. Conclusions in the right.
Yes. Yes.
And Lord, let me just check if there was anything else I wanted you to. If I can ask you to turn to page 8, discussion.
Yes.
If you could just read that paragraph there. I don't think you need to go over the page.
Yes. Thank you.
Paragraph 47 of the skeleton argument, penultimate line. Dr. Pedden also considers reasons for a lower rate of adherence to home quarantine and the survey and qualitative data for non-adherence to home quarantine. And that is paragraphs 12 to 15 of her affidavit. Lord, you may have already read this.
Yes.
And if that's the case, then I'll take you to tabs 5 and where necessary through to 9 of her exhibit, starting at tab 5. Tab 5 is a report produced by Bodas and Peleg, and it is in respect of self-isolation compliance in the COVID-19 era, influenced by compensation. Findings from a recent survey in Israel. Lord, if I can ask you to look at the discussion on page 938. And effectively, this was saying the inability to earn incomes at the time of isolation can severely impact a person's adherence to the quarantine measure. And then Lord, I am not sure we need to look at anything more. Paragraph 48 of the skeleton argument, the Minister of Health provides 6 examples of individuals breaching quarantine requirements. It is clear from the examples that there is a risk of a link, that there is a link between the factors of non-adherence set out in Dr. Pedden's affidavit and the examples of non-adherence in Bermuda. For example, a factor in non-adherence was financial. An example 4 breached quarantine to attend work. The key consideration for Bermuda is the consequences that could result from a single breach. Example 1, we've discussed that, my Lord. The outbreak at the party is believed to have led to the most recent and worst outbreak Bermuda experienced, resulting in 21 deaths. 50, the cabinet considered alternatives to hotel quarantine, such as home quarantine with regiment checks or monitoring electronic bracelets, but considered them to be both impractical and ineffective. As well as data and scientific evidence set out above, the following was considered by the government. There were three factors, additional factors that they considered. Firstly, the government does not have the resources to deploy the regiment for this purpose, and in any event does not consider it an appropriate use of the regiment. Two, the issue of visitors to a residence makes it considerably more difficult for the government to contact trace, because persons in quarantine who have invited visitors to their residence and those persons attending the residence of those in quarantine are less likely to admit the same, as this is an offence punishable by fine. This impacts the Ministry of Health's ability to contact trace accurately and efficiently. C, the examples of breaches of the quarantine provided by the Minister of Health that resulted in infection, outbreaks, and in one case, a large number of deaths, all occurred in circumstances where the government had in place less restrictive means, such as quarantine at home. There are no similar examples when the government had mandated quarantine in a hotel last year for travelers to Bermuda.
What do you say to Mr. Pettingill's argument that, well, this could all be sorted out if you had massive fines and threats of imprisonment?
I mean, I think that's a socially and politically unattractive approach to take when you have a measure that is less of an imposition on people than what he's proposing. I mean, you know, if the government is seen to be ramping up the legislation on prosecution and ramping up the legislation on fines, that looks even more oppressive. It's just a threat over the heads of the public. I mean, this is a measure that is calibrated to allow people to travel, come back. Yes, you're not vaccinated. You quarantine for a period, and then you maintain the safety of the public because there's no additional threat. And it's for a limited period that the confinement takes place. I just think the government, I mean, my Lord, you're probably aware, well, I shouldn't say you're aware, because I'm not going to suggest that you are a social media adherent, but the level of criticism that the government takes when making measures like these is you know, obviously going to be wide and varied. It's very difficult to satisfy everybody with measures like these. But were the government seen to be ramping up fines and ramping up the possibility of imprisonment, I think that would be equally disapproved by a wide section of the public.
So, my Lord, is that just, I'm going to follow on with this later if I may, just interject at that point. Is my understanding, and perhaps you can just follow up on this, but the respondents have issued or tabled legislation for having on-the-spot fines. As I understand the current position, and they've actually ramped up the fines, which is a little bit contrary to what my learned friend was saying there. Perhaps he could confirm that. I'll certainly follow up on that as best I can. There's been reports in the paper on that, but as I understand it, that is the position, that there is currently legislation on the table with regard to on-the-spot fines and the ramping up of fines.
I think the answer to this, my Lord, is there's no evidence that this would, in fact, reduce the number of breaches of the regulations by people either leaving their homes or allowing visitors to come to their home. There's just no evidence of this.
Yes.
So paragraph 52 of the submissions, the requirement for unvaccinated travelers to quarantine in government authorized hotels is, and we're saying this in connection with the De Freitas test, rationally connected to the statutory objective that has been put in place with the order, and it's connected to public safety and public health. The data and scientific evidence could not be clearer. Home-based quarantine leads to increased transmission. This has been borne out in the actual examples cited by the Minister of Health. The less restrictive measures likely resulted in 21 deaths. In the circumstances, the court should not interfere with the requirement to quarantine in a government authorized hotel. And again, Lord, this is another Dolan scientific data, Rotherham case, allocation of resources, wide margin of appreciation that you should add to your consideration of the De Freitas test, this limb of the De Freitas test.
Yes.
Cost to the traveler, paragraph 53. The policy decision for unvaccinated travelers to bear the cost of the hotel quarantine is one that the executive is much better equipped to assess than the judiciary, as in the present case. It involves the allocation of money and differing competing political, economic, and social factors. Lord, if I can remind you of
Rotherham?
yes, at paragraph, if you just cross-reference paragraph 19F of the skeleton argument. That contains the two relevant paragraphs in the judgment, paragraph 61 and 62.
Yes, we looked at them before.
Yes. So we would say that, again, wide margin of judgment based on that legal proposition. Paragraph 54 is a reference to paragraph 11 of the Premier's affidavit. That can be found at tab 16.
Yes.
That is a policy decision which the court should give the Premier and the Cabinet a wide margin of judgment to determine. Paragraph 55 and 56.
Yes.
Well, now we get to the third limb of the De Freitas test. Are the means to achieve the objective which impair the fundamental freedom no more than is required to accomplish the objective? So is the imposition of the 14-day mandatory quarantine period and the cost of that no more than is necessary to achieve the objective of preventing variants of concern and the virus spreading within the jurisdiction? Lord, we identify four grounds that we want to go through. My Lord, I'm wondering whether we could just have a short break for a few minutes, just a couple of minutes.
Yes, of course we can.
Yeah.
We'll take a break for 3 minutes.
Yes, okay, thanks.
Detaining children is also made on there about the children. In which they tell us, like, what was the purpose?
Yes, I think we're all here, Mr. Duncan.
Thank you for that time. What I want to do, my lord, is if I can, just take you back to, in particular, paragraphs 47 through to 52.
Of your submissions?
Of the submissions, yes. And
yes,
I think we can just hold a thought as to whether or not what I'm about to say also applies to paragraph 53 to 56. But let's just deal with the real guts of the opposition in this case, which is 47 to 52. Yes. What I'd like to do, my lord, is have you make a legal note, which is a gloss on the margin of judgment submission that I've made thus far. I've already referred you to Rotherham and Dolan in terms of margin of judgment. Now, my lord, I'd just like to, if I can, assist you with the analysis you should perform when you conduct the exercise in relation to, in particular, hotel quarantine, but maybe also costs. We'll see. Lord, and it will be short, but it's important. And it is found in the Scottish minister's case at paragraph 105. This is the approach we think the court should take. And the heading is significant because it replicates the submissions that my learned friend is making, i.e. less intrusive means. What is the judicial approach to a submission in that context?
Paragraph 105, yes.
Let's start at 104. I'll just read briefly. The question at this stage of the test is whether a less intrusive measure than closing places of worship on pain of criminal sanction could have been used without unacceptably compromising the achievement of the objective of maintaining public health and preserving life by reducing the risk of infection from coronavirus. The approach at this stage has been summarized by the Court of Appeal in our Fact versus Environment Secretary of 2020 case as follows. One, the decision maker has a margin of appreciation, we say that should be judgment, but in any event, or discretion, which is highly fact and context specific. The evaluation will take account of all relevant circumstances, including conditions prevailing at the time the decision was taken, and the reasons given why less restrictive measures were rejected. A measure will be disproportionate if it's clear that the desired level of protection could be attained equally well by measures which were less restrictive. Yes. Well, we already know paragraph 3 because of the fact we're under the reasonably required test in the Constitution. 4, the decision maker is not required to consider every possible alternative. 5, the mere assertion that some other measure is equivalent and less intrusive is not sufficient. And equally, the fact that some other measure can be envisaged is not enough. 6, it is relevant that the measure is general, simple, and easily understood and readily managed and supervised. So,
what does subparagraph 5 mean?
What paragraph?
what is required in order to run the argument if a mere assertion would not do?
There needs to be evidence produced. The other side must produce some evidence in support of their counter assertion. They've produced none. So, my lord, and you have it here today. And I say this with no disrespect to my learned friend in terms of the submissions yesterday and today. What you have is a policy decision that is taken by the ministry, supported by the Premier, with evidence. We've been through that. And what you have is on the other side, well, what about this? And what about that? And what about this? But no evidence. So is the government supposed to jump at each one of the suggestions without evidence? No doubt it would be blamed if that policy suggestion didn't work as well. There's got to be some evidence, some rationale basis in support of what they are doing so that the court can weigh the two. And I think that that's our response to number 5.
My lord, if I may, and very briefly, I'm right to interrupt my learned friend, but on that,
No. I a full opportunity. You'll have a full reply. I think otherwise
I didn't interrupt anybody on the side.
I apologize.
Yes, Mr. Duncan.
Lord, in respect of number 2, under the fact environment case, Roman numeral 2, where it says a measure will be disproportionate if it is clear that the desired level of protection could be obtained equally well by measures which were less restrictive. There's no evidence. Again, they have to produce evidence. They can't just throw out assertions.
Yes.
And with respect to number 1, I've already mentioned that the court should give the policy decision makers a wide margin of judgment with respect to how they take into account and balance all the circumstances that were used to arrive at their policy decision. Now, my lord, we submit that that is the approach you should take when looking at the Freitas test with respect to hotel quarantine, the Lim 2 de Freitas test. And that's how you analyze and weigh the competing submissions you've heard in the evidence that we filed and in the evidence that's been filed by the applicants and the submissions that have been made by my learned friend.
Yes.
My lord, I think we're on to the third limb of the Freitas, and I've already indicated what that is. And I've highlighted, although I may not have actually highlighted paragraph 57, I think I'll do that. As submitted above, this is a case where the de Freitas factors inevitably overlap. You'll recall, my lord, the last sentence in the judgment of Lord Sumption in Bank Mellet, where he said that you don't look at these factors in isolation, because the same factors are likely to be relevant to more than one of them. Above, we have set out the evidence as to why the means are no more than is necessary to accomplish the objective of public health and public safety. However, the following point should also be considered. Lord, I'm wondering whether you could just have a read of those 4 points.
Yes. Yes, thank you.
Lord, paragraph 58. I've mentioned already. Now, my Lord, that effectively is our case in response, Lord. But I couldn't tell from the submissions that were made both by my learned friend and leading counsel whether they believe that we have the burden of demonstrating that our conduct with these policy decisions is reasonably justifiable. I'm on paragraph 59 now. My Lord, I don't propose to address that in any detail. I think that in order for the court to have shifted the burden to us, we would have to be going against the decisions of former Supreme Court judges and indeed the weight and body of academic learning on this issue. So my view is that in the event the court is going to take a different view, and you'll hear from Mr. Pettingill on this point, then I would like to just briefly reply on that, but I don't plan to waste the court's time going into a defense of the reasonably justifiable test as it applies to the state as an additional added limb to the de Freitas test. I don't plan to do that.
Yes.
My Lord, that being the case, my Lord, I pose a scenario, Lord, and that scenario is that on one view, it could be said that we satisfy the three-limb test of de Freitas. Where are we left then? We are left with the burden shifting to the applicants to satisfy the reasonably justifiable test. That's confirmed in Benavides, that's confirmed in Rayner, that's confirmed in Saunders.
Yes.
Paragraph 61 of the skeleton argument. We say that the evidence in support of the expedited originating summons is woefully inadequate in this regard. So in effect, my Lord, what we're doing, and I suppose it causes a bit of a procedural conundrum that we have to address, is this. We have to assume, my Lord, that you could rule against us. And if that's the case, the burden shifts back to the applicants. And we haven't considered whether or not we would have a right to respond to their evidence. Now, this is why the logical and most practical way to look at how the evidence is being considered is that the submissions that were made by the applicant really were a response to the three criteria in de Freitas. And if not that, they were a response to our response to the three criteria in de Freitas. And so we then get to a point where we have to assume that's their response. And then that evidence becomes the evidence, because we've heard nothing else, that we assume they are relying on for the burden having been shifted to them, if that makes sense more.
Yes.
And so we now counter that in paragraph 61A by saying that there is no evidence from an expert with any relevant expertise. And then we refer to paragraph 61B and the consideration, my lord, that we believe you gave at the last hearing to the expert evidence filed by those two doctors referred to in paragraph 61B. And then we see in paragraph 61C the support for the Pfizer vaccine that is contained in paragraph 22 of Dr. Dowling's affidavit. My lord, then in paragraph 61D, I just want to see whether, just have a look at the judgment that you delivered. 14. Well, I just want to, just give me a moment. I'm looking at paragraph 48 of your judgment. I'm not asking you to go there. I just want to see if I can make a point. Well, the only point we make is whether or not the evidence that their doctors rely on, the way they put it, seems to be taking away your jurisdiction to make certain decisions. That's paragraph 61D. We know that you'll be alive to that.
Yes.
Did you want me to take you to those paragraphs in their affidavits?
You've given the references. I'll
Yes.
have a look at them.
Paragraph E. There is no scientific evidence on the level of adherence to at-home quarantine. And so in paragraph 62.
So what are you saying under subparagraph E?
That there's an assertion.
Oh, I see. Okay.
But there's no evidence with respect to adherence.
Yes.
So paragraph 62, we say, based on the evidence relied upon by the applicants, they simply have not even began to meet the burden of proving that the order, and section 13 in particular, is not reasonably justifiable in a democratic society. So, my lord, we would say that, my lord, and I can see you look at the clock, we will. Did you want to stop now, my lord?
How long how long will you be to complete, or do you want to come back?
Yeah, I could come back. I'm not going to be long at all. And in fact, by the time I come back, I should, I don't want to overpromise, but I should be in possession of the affidavit that will respond to my learned friend's request for the information.
Yes. All right. Well, why don't we take the short adjournment, and we will resume. How long are you likely to take, Ms. Bettingill? Just not holding you to it.
I appreciate that. I'd like to think perhaps an hour in response, my lord, at the outside.
Would you like sort of for us to start at 2:30, so give you more time to consider?
I'd be obliged. I was going to request that. I think that would probably be time usefully spent.
Yes. So no, that's fine. So in that case, we'll adjourn now, and we will resume at 2:30.
Thank you.
Thank you.